We'll move to some financial cases now. Now, what's interesting here, and I talked about the tax court process, is that tax courts in some way seem favorable to the claimant. Not only did the first case of ACSIS win the claim, but they also got their full legal costs reimbursed, not the stipulated nominal amounts that the courts often pay, the full legal fees. And this is basically a trend that judges are taking if they feel the CRA has taken a harsh or frivolous position against the taxpayer. So maybe this is an incentive to go not informal appeals, but really go for the general procedure if you've got a strong case. The one real issue here is if they keep settling ahead of your hearing, you don't get any precedent, so the problem doesn't resolve itself. It's just your one client got away, but your whole industry really lost, and you'll eventually lose at the end too, because they'll come back for you. All right, basically, according to the judge, there are circumstances where judges are allowed to award more cost. It's covered by the Tax Court of Canada rules and the Tax Court of Canada Act, so they can extend it up to the full cost of reimbursement, and in this case they gave it 95%. Okay. So the factors that they'll consider are the amounts in issue, importance. Basically, were both sides nice? Did they make offers of settlements, complexity, conduct of the parties? Did they unnecessarily delay things? All of these things, because I mean, if you're in CRA objections or reviews and you've waited 2 or 3 years, you may argue that there was undue delays, and the judge may take some of these things into account, right? Failure to admit something, whether they feel it was unnecessary or vexatious, whether expert witnesses should have been required or were required and weren't required. Basically anything relevant, the judge can use this to say, well, the fees should be increased. And I think this is significant in the overall scheme of, do I go to tax court or do I just, walk away at the objections level? Okay. So the judge said in this case, 95% was based on the appellant's willingness to settle and the refusal of the CRA and the Crown to basically be reasonable in the judge's view. Okay. So everything I said about tax court, now I take a step back and say, well, maybe there is some merit in it after all.